Good morning and welcome to today's administrative meeting of the Maryland Public Service Commission. Before we get started, I'd like to revisit the minutes that we had for our last meeting, which was held on March the 13th. If the commissioners have had a chance to review the minutes, is there a motion to approve?
Yes, Mr. Chairman, I move we approve the minutes from the March 13th administrative meeting.
Thank you. Is there a second?
Second.
All in favor? Aye. The minutes are approved. Before we get started with our consent agenda today, I'd just like to recognize one of our employees from the docket room, Kim Canada. Is Kim here? There's Kim in the back. Kim was recently promoted to our docket room supervisor. It's a very important position at the agency. For those before us who have to file the 17 copies, those will go through Kim's hands, and we appreciate having a good supervisor in that dockets room to make sure all of our paperwork and the important filings get to where they need to go. So thank you, Kim, and congratulations. We have a heavy agenda today, so why don't we get started with the consent agenda, Madam Secretary?
Yes, Mr. Chairman. There are 6 items on the consent agenda. The first item is Eureka Telecom, Inc., DBA, Eureka Networks, DBA, Info Highway Communications, filed on March 1, 2019, request to withdraw CLEC IXC certification effective April 1, 2019. The second item is Olympus Holdings II, LLC, filed on March 4, 2019, notice of indirect transfer of control of West Safety Communications Inc. at West Telecom Services, LLC. Item 3 is Great American Insurance Group, filed on December 26, 2018, notification of cancellation of the bond issued for Gotham Energy 360, LLC. Item 4 is Source Power and Gas, LLC, filed on February 14, 2019, a request to cancel its license to operate as an electricity supplier in the state of Maryland. Item 5 is NJR Clean Energy Ventures 2, filed on February 26, 2019, amendment to certificate to reflect new ownership. Item 6 is New Wave Energy Corp., filed on November 30, 2018, an application for a license to supply gas or natural gas supply services in Maryland.
Thank you. Do commissioners have any questions with respect to these 6 items on the consent agenda? Seeing none, is there a motion?
Yes, Mr. Chairman. For item number 1, I move that we rescind the company's authority to operate in Maryland and cancel its tariffs. For item number 2 and 3, I move that we note the filings. For item number 4, I move we approve the cancellation request. For item number 5, I move we note the change in ownership. And for item number 6, I move that we grant the company a license to operate as a natural gas supplier in Maryland for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and trading materials specific to its Maryland operations to the Commission staff and Office of People's Counsel 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you, Commissioner Linton. Is all in favor? Is there a second?
Second.
All in favor? Aye. Thank you. These motions are approved. Madam Secretary, the administrative agenda.
Moving to the administrative agenda, item 7 is Chop Tank Electric Cooperative, Inc., filed on November 6, 2018, proposed tariff revisions to its power cost adjustment tariff.
Thank you. Good morning, Mr. Spivak.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is Chop Tank Electric's revisions to its power cost adjustment tariff. The purpose of the filing is to revise the conditions applicable to the PCA to reflect the adoption of time-of-use rates. On November 28, 2018, the Commission approved time-of-use rates for Chop Tank's rate schedules GT and PT in Mail Log 221557 and 221026. These revisions were scheduled to be effective January 1st, 2019. In its current filing, Chop Tank proposes to modify the conditions that determine when Chop Tank can file to change a PCA factor that has been in effect for less than 12 months. Additionally, Chop Tank is proposing to adopt a separate PCA factor for standard service and time-of-use sales service. Chop Tank has informed staff that Chop Tank is still testing the time-of-use rates and that Chop Tank does not expect to utilize the approved rates until July or July 2019 at the earliest. The PCA is a reconciliation mechanism designed to reconcile Chop Tank's purchase power costs and Chop Tank's recovery of those costs. Currently, the PCA factor is set for 12 months and subject to an annual hearing pursuant to Public Utilities Article Section 4-402D. PCA factor is applicable to all sales. Staff agrees that separate PCA rates for time of use and standard sales are warranted to ensure that costs associated with time of use service are not subsidized by standard service. However, in view of the fact that the approved time of use rates have not yet been implemented, it is impracticable at this stage to design separate PCA rates for time of use and standard service. Accordingly, the proposed tariff should be rejected and all costs should be reconciled in Choptank's next review proceeding in case number 9503N. Staff recommends that the Commission reject Choptank's proposed tariff changes and direct Choptank to 1. Notify staff when they begin to sign up customers under the new time of use rates. 2. File testimony in case number 9503N that fully explains the proposed calculation of a separate PCA rate for standard sales and time of use sales. And 3. File in case 9503N a separate PCA tariff mechanism for standard sales and time of use sales.
Thank you, Mr. Spivak. Is counsel for Choptank? Why isn't Choptank here? Mr. Spivak, do you know why Choptank is not represented today?
I do not.
That's unfortunate. Counsel for the People's Council.
Thank you, Mr. Chairman.
Mr. Raker, do you know where Choptank is?
I do not, Mr.
Okay.
Chairman.
I'm informed by Mr. Patterson that Choptank basically did not intend to be here because they were okay with what we had to say here.
Okay, they should put that in writing. Mr. Raker.
Thank you, Mr. Chairman. Mikhail Raker on behalf of the Office of People's Council. Make my comments very brief. We generally concur with staff's recommendations. The two minor amendments, we'd also ask that OPC be notified by Choptank when it begins to sign up customers under its newly approved TOU rates, and that Choptank also file all work papers with their testimony in case number 9503N. And with that, I'm available for any questions.
And it is your understanding that Choptank agrees to these conditions?
We were not in communication with Choptank, but we were in communication with staff, and from staff understand that Choptank does agree.
Yeah, seems like Choptank needs to improve its communications. Is that Choptank's understanding, Mr. Spivak, that they would comply with these conditions?
Yes, they've essentially agreed to our terms.
How did they do that, in writing or orally?
It was orally.
Okay. Thank you. Do commissioners have questions?
I guess just for my background, I'd be interested to know, since you agree that there should be a separate PCA for time of use rates, and it sounds like they've begun the time of use rates for a limited number of residents or participants. Is that correct? Do I understand that correctly?
I think I'll let Mr. Patterson speak to that.
Morning, Chairman and Commissioners. Felix Patterson on behalf of the Commission, on behalf of staff. The time of use rates that you're talking about now are time of use rates from an old closed tariff that they have in that they had in use. So it's not the time of use rates that they're putting in for the new tariff. So they don't have any customers for the time of use rates that they get ready to put into effect right now.
Okay, I thought they were testing this with a limited number of customers.
and
And I
so-
was just going to ask the question, what's the harm in implementing a time of use PCA now as part of the testing process? But you're saying they're not really testing the
No, the
rates.
time of use rates, time of use customers that are in effect right now are from an old closed tariff. So, but the time of use rates that they're proposing now, they're looking for new customers, and they don't have any new customers on that time of use rate right now.
Okay, thank you. Again, the way I read this, I thought that they were starting to test a new time of use rate. So that answers my question. Thank you.
Thank you very much.
Any other questions? Commissioner Herman.
Oh, thank you, Mr. Chairman. Mr. Raker, what was the second condition?
Second item was in number 3, noted in our letter, simply requesting that Choptank also file all work papers with their testimony.
Is it not customary that they would file work papers with their testimony?
I'm not 100% sure if it is customary. Usually that's requested after the testimony is filed via data requests. It would just expedite the process if they were to include that right away.
Mr. Spivak, do we
I think-
need to direct them to do that, or is...
I think it might be helpful, Commissioner. One of the things that happens is Chop Tank's testimony tends to be filed fairly late in the, before the hearing in the annual PCA case. So there's not a lot of time in between Chop Tank's filing and the hearing to review things. So anything we can do to expedite that would be helpful.
Okay, thank you.
Why don't we add that directive to the motion? If commissioners don't have any additional questions, is there a motion?
Yes, Mr. Chairman. I move we reject Chop Tank's proposed tariff changes, direct Chop Tank to notify staff and OPC when they begin to sign up customers under the new time of use rates, direct Chop Tank to file testimony in case number 9503N that fully explains the proposed calculation of a separate PCA rate for standard sales and time of use sales, and to file work papers with that testimony, and direct Chop Tank to file in case number 9503N a separate PCA tariff mechanism for standard sales and time of use sales.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Thank you, Commissioners.
Item number 8 is Baltimore Gas and Electric Company, filed on February 22, 2019, calculation of the gas administrative charge under Rider 12 of its gas service tariff, effective April 1, 2019.
This is a revision to BGE's Gas Administrative Charge, or GAC. The gas administrative charge is paid by customers receiving gas sales service from BGE and is intended to cover the gas commodity portion of credit and collections cost, commodity billing, uncollectibles, and the PSC assessment. The charge is being updated on a semi-annual basis. Staff has reviewed the gas administrative charge calculations and determined that the revised calculations are accurate and consistent with the calculations required under the Case 8950 settlement that created the mechanism. The filing reduces 3 of the 6 components of the gas administrator charge and leaves 3 of the components unchanged as detailed in staff's comments and the filing. Staff recommends that the Commission accept the new gas administrative charge tariff for filing effective April 1st, 2019.
Thank you. Good morning, Council for Baltimore Gas.
Good morning, Commissioners. Beverly Sikora for BGE. Just want to clarify one thing Mr. Spivak said. We actually make this filing normally annually, but because some components of the GAC calculation are dependent on rate case data, we also then update it when a rate case is concluded because we use some of the final numbers then there to do some of the calculations. So in this case, this filing was precipitated by the order in our last rate case. So again, normally it's just done once a year, but again, after we have a rate case, we reset numbers based on what was in the rate case.
Thank you for that clarification. Do you have anything additional to add based on Mr. Spivak's recitation?
No, I don't. I'm available if you have any questions.
Thank you. Do the commissioners have questions on this item?
Just a quick question. When would we expect your next annual filing?
Usually it gets filed in the fall, could be, September, to be effective November 1st.
Okay, thank you.
Thank you. With that, is there a motion?
Mr. Chairman, I move we accept the new gas administrative charge for filing effective April 1st, 2019.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Thank you, Commissioners.
Item number 9, Great Bay Solar 2, LLC, filed on October 5, 2018. Request to extend and amend CPCN construction deadlines, case number 9380.
Thank you. And do we have counsel for Great Bay? Thank you. Good morning.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item 9 is a filing by Great Bay Solar 2, LLC, requesting to extend the start of a construction deadline for the second phase of the solar generating facility by 8 months. In case number 9380, the Commission by Order 87690 authorized the construction of a 150 megawatt solar generating facility in Somerset County, which was to be done in 2 phases. The first phase of 75 megawatts began commercial operation in early 2018. Condition 4 requires construction of the second phase to begin by December 30, 2018, and the filing requests 8 months of additional time for local permitting as outlined in their filing. Staff reviewed the filing and provided comments, recommending that the Commission grant the extension of the deadline to commence construction to August 30, 2019, and to also require the company to file an updated interconnection services agreement to reflect a commercial operation date of December 2020. The Power Plant Research Program then filed a letter on March 20, 2019, mail log number 224379, noting that the county review may result in changes to the site plan, and states that it would file recommended conditions for the second phase within 60 days of receiving the final site plans for phase 2 of the project. Since then, Great Bay, through their attorney, has contacted staff with a revised proposal based upon the PPRP letter, which they indicate they will present here. Staff lastly notes that the Commission, by a letter, granted a temporary extension of the construction deadline to allow the proposal to be considered at this administrative meeting.
Thank you, Mr. Dean. Counsel for Great Bay.
Good morning, Mr. Chairman, Commissioners. Todd Chasen on behalf of Great Bay Solar 2. Let me back up just a little bit, but the punchline to all of this is I'm happy to be here asking the Commission to do absolutely nothing today. We originally filed our request for an extension of the deadlines last fall. That was granted by the Commission by the letter dated November 5th, and it basically pushed the pause button until the parties came back with new proposed conditions, including with respect to the deadlines. Fast forward, now here we are with that information. What PPRP's letter says in a nutshell is that it would like to have site plan approval at the local jurisdiction level before it proposes conditions. While that's not the way that this is typically done, we're okay with that, and we think that that's a reasonable way to proceed. We expect that sometime in the next couple of months, we don't know precisely when, but we expect that site plan approval will occur later this spring, and that we'll be back with proposed conditions in conjunction with discussions with all of the parties, probably in or about August. So at this point, we don't know whether those originally requested deadlines make sense. It'll depend on what those new conditions are. I am able to update the Commission that the local jurisdiction had a hearing last night with respect to two issues they were concerned about. One of them was some road paving that needed to be done. The other was with respect to buffering. The local jurisdiction is satisfied with respect to both of those issues at this time and has indicated that it can move forward with site plan review of Phase 2, has also indicated that the clearinghouse process that's currently pending before DNR can move forward. So I'm happy to answer any questions, but at the end of the day, I think all that we're asking is for a continuation of the temporary extension that was granted last fall.
So, Mr. Chasen, you're not requesting the extension of the deadline today. Is that correct?
No, sir.
I know there's a number of other parties, so before we continue any question, we have representatives from Attorney General's, DNR, and PPRP with us today. Do any of those parties wish to make any comments?
Good morning, Mr. Chairman and Commissioners. Steve Tolson, counsel for PPRP, and with me is Bob Szynski, who's the project manager for the Great Bay Solar. I believe that Mr. Chasen's comments are accurate. We filed with our letter that we filed in March a recitation of some of the issues that we'd run into with Phase 1 that created problems, but those have mostly been addressed. There have been lessons learned, and that's why PPRP wants to see the final site plan, which, as we said in our letter, could change significantly between now and the time that the county approves it, so that we can provide revised conditions. As you know, neither the statute nor the code really contemplates these phased constructions. You have a CPC in, and you go forward with it. But as we're seeing with some of these larger projects, and we've got more in the pipeline, the applicants like to do them in phases, and this phase will not meet the full 150 megawatts. There could be a third phase. So PPRP wants to preserve the right to look at these change conditions, to adopt best practices and lessons learned, and make sure that we protect the public and the state when we file revised conditions.
Thank you. Mr. Tolson, you would be asking for 60 days beyond receiving the approval from the county?
Yes,
okay.
That's what we'd ask for.
All right, before we open up to questions, I see Others, sir, do you wish to testify?
Yes.
Please do. We can make room at the mic. If you could please state your name.
Ronald D. Clement.
Okay, if you could approach the secretary.
I have it prepared.
No, no.
If you could just provide it
need
to the
6
secretary.
copies,
Yes.
and I will distribute them to the commission. Thank you. Thank you.
Mr. Chairman, I have not received a copy of what's being handed out, and I would...
It looks like he has plenty of copies, Mr. Chasen. If you
I'm
just...
just noting my objection without having had the courtesy of seeing this before this time.
Sir, if you could provide copies to the parties, including council and representatives from DNR and PPRP.
Well, I actually brought 17 for the commission.
Okay.
But they can certainly look at one as I speak. Not a problem. You want to take one of them? One of the copies of it.
We need one for the record. That's okay. I will need another copy of these and that because I've got 5 commissioners, but I need something for the record. So if anybody ever asks, okay? Do you need one of these?
Yes.
Well, then that means one of the commissioners doesn't have it.
As soon as I'm finished, I give it to you. My name's Ronald D. Clement, and I'm here to testify about Great Bay Solar Stage 2. And I'm a citizen of Somerset County. I want to refer you to the outline, and then we'll go through page by page. Does everyone have a copy of the outline?
We do have a copy, sir, but we'll need to make this relatively brief. There are a number of pages here, so if you could
Yes.
summarize in about 10 minutes.
Yes,
Thank you.
absolutely.
Thank you.
Okay. Number 1 says that we're here to ask for a cease and desist on Stage 2 activities until all the Stage 1 obligations are met. Stage 1 obligations were not satisfied. Algonquin purchased from Pioneer Green Great Bay Solar. Algonquin is a company that has $9 billion in assets. Last year, and that information's here, they had a 24% profit margin. That information is here on the first couple pages. You can look at that. With Stage 1, there were 26 lawsuits filed against Great Bay Solar, 23 of them for non-payment. When we went to review those law cases, we found that the majority of them were settled out of court at a reduced amount.
Sir, sorry, just to be clear, what is your standing? You're a resident of the
Yes.
county? Okay. Do you have any other position that you're representing? Are you counsel to any party?
No, I'm not.
Okay, thank
Well,
you.
I'm representing several citizens, yeah.
You are? Okay.
Yes.
Are you a member of the bar?
No. So there were, I'll resume where I left off. There were 23 lawsuits against Great Bay Solar 1 for non-payment. When I reviewed those cases, several of those had to be settled out of court, some for less than 50% of what they signed the contract for. In fact, the young man that works for the roads department in our county mowed the grass outside the fence and he was never paid. One of these lawsuits I found is still open. The substation has not been paid, and the substation still has an open lawsuit. There's 3 lawsuits here that are open that are in appellate court at the moment. Those 3 lawsuits involved ingress and egress violations.
Okay, sir, we're not a court of law. Apparently, these are being handled in court. Is there relevance with respect to the PSC's jurisdiction?
Yes. Yes, several of these were settled, did not reach the court. So basically, basically, in a nutshell, is they signed a contract, they did the work, they were not paid, they had to file a lawsuit, then they had to bargain with the company and settle for less money. For the couple that I saw, I know some of the contractors. Phoenix Solar did the majority of the work. Phoenix Solar, I'm putting a little clip here on insolvency proceedings because Phoenix Solar is in the same situation where they were not paid, and so there's they're a German-based firm, but they've are in the same situation where they're not being paid, and these type of business practices should be investigated before stage 2 was to begin. If you refer a little bit further down the outline, Maryland Department of the Environment, they were fined $45,000 a day during almost the entire construction phase. There were violations and the fines were accumulating. I've included the letter here. It mentions the violations, and they were receiving, as I said, $45,000 a day worth of fines, which accumulated to, roughly doing the math, over $4 million worth of environmental fines. For some unknown reason, the letters included, they settled by paying only $400,000 of those environmental violations. Next issue on here is the buffer. I've given you pictures. We were told the Public Service Commission ordered full vegetative buffering to a height of 8 feet. If you take the large picture 1, this is the full vegetative buffer. This is their idea of the full vegetative buffer. There's a few deciduous plants in a row. And picture 2 shows down the road, again, what they're calling the full vegetative buffer. Picture 3 shows the buffer in summertime, which was overtaken by weeds.
Now, there is obviously no meaningful buffer here, but I understand from Mr. Towson's comments and Mr. Sadinsky's comments that this was recognized as an inadequate buffer in their letter of March 20th, and they had photographs attached as well.
Yes, I will get to that. And then here's
my understanding is that this has been remediated. Is that not true?
That the buffer was remediated?
Yes.
The buffer was only remediated because they're trying to get stage 2 started. Until the county said we need a proper buffer, nothing was going to get done. We were told this was all they could do, and it wasn't until stage 2 proceedings began and the county said the citizens are concerned about 0 buffer, basically no buffer, because we were told this is economically feasible is all they could do.
Okay, so these photos are out of date, though. The buffer is now in place. Is that right?
I have pictures of that.
Okay.
This was, photograph 5 is last summer's maintenance. Panels were covered in weeds. Photograph 6 is the unfinished roads. Now all this is being remediated because they're trying to get stage 2 started. We have no guarantee if there was no stage 2 that this would have ever been done. in the small pictures, I think there's in the small pictures, 5 and 6, she mixed these up a little bit, but 5 and 6 shows the buffer that they've added for the purpose of trying to get stage 2 started. And I'll give you my copies too when I'm finished. But this was the buffer that they've now put in, which we were told was not feasible last summer. It suddenly has become feasible when they want stage 2 to begin. So that takes care of the buffer. Let's go to the Maryland Historical Trust. The Maryland Historical Trust signed off on the project and said it was met to their approval. The Maryland Historical Trust, we've notified them, here's an archaeological site, 7 and 8 numbers, which is completely inaccessible to the parties that have family members there, which is against Maryland state law. And we contacted the Maryland Historical Trust about this, and they've just brushed it off, basically. But this...
What do you mean there's no access to...
There's no access to the... could I step forward?
We could see from there.
Okay. This is gated off here,
You
and
need-
the
I'm
cemetery
sorry.
sits over...
I'm sorry. You need to go back to the
Okay.
microphone because we're recording this and people can't
Yeah.
hear you.
This is gated off, and it's over 100 yards to reach the cemetery, and the family has no access. And this shows the condition of the cemetery because the family's not able to maintain it. You can see the stones in the close-up picture. There are some grave marking stones there in the close-up picture, but the family has no access, which violates state law, and the Maryland Historical Trust is not acting on this in any way whatsoever. And the family's not able to get in to maintain this in any way possible.
I do not know if that is law or not, but that's outside of the jurisdiction of the PSC.
Okay. Well,
Fine points you're making,
Yeah.
but not before this package.
It is Maryland state law, though. And then parcel 1 and 2, which are in the packet, parcel 1 and 2, which are actually behind the farm that I own, I've included that. The ingress and egress there will be basically impossible because the lane that they're planning to use is not between the adjoining properties. It sits to the Adams Farm, which is a National Register property. That ingress-egress line sits on the Adams Farm property. And the Adams Farm has given permission for the adjacent property owner to use it for agricultural purposes, and it's maintained by the Adams Farm. So there's no ingress and egress to that location. The entrance to that sits 150 feet from an apartment complex which has children playing out there on bicycles and tricycles and all different things every warm evening of the year. And it is exactly 1/2 mile from the high school on that road that comes up there, and the high school students walk that road all but July because of sports, and there's no shoulder on that road. So parcel 1 and 2 has no ingress and egress that will be safe. There's safety factors involved there. And I've included pictures of, if you look at, well, I'll get to that in a minute. But if you look at parcel 1 and 2, and flip through the packet, in our zoning code, it says that it has to be, ingress and egress have to be a safety factor and a consideration for the public. And that will not take place with parcel 1 and 2. Additionally, the house that is...
Sir, with all due respect, many of these are zoning-related ordinances, so the commission cannot provide any relief on item number 8. So why don't we move to your next item, number 9?
Well, I'm saying that the Somerset County zoning ordinance, and I included that in here, speaks about the safety of the residents. Parcel 1 and 2 in this case has no ingress and egress that is even remotely safe because of the high school, no shoulder on the road, an apartment complex with children playing there.
I recognize that is a safety concern, but it's not before this commission.
So, And then lastly, the Maryland Historical Trust, even though they have said to you that they have signed off on the project, they identified this house as the National Register property. They identified the Ross Farm as the National Register property, and they made concessions for this house by moving the solar fields so they would be entirely out of view. Okay? Our farm is this house. They did not recognize it a National Register property, for which we're going to proceed with litigation against the trust unless they begin to intercede and to do work for us. And this is unrecognized as a National Register property, and it's not even mentioned anywhere in the 106 review at all. There are several pages of, which I have included in my packet, several pages of mitigations discussing Cedar Hill Farm. There are several pages of litigation, several pages of dialogue on Cedar Hill Farm as far as making mitigations so that the solar isn't in view of the National Register property house. There are several pages concerning the Ross Farm as being too ruinous, so that's why they didn't consider that.
Are you the owner of Cedar Hill?
No. I'm the owner of the Adams Farm, which is the third one that was not recognized as a National Register property when it is. And when I contacted Elizabeth Hughes said she didn't know.
Okay, again, that's a matter of the designation of historical trust properties is not before this commission.
Yes, but the trust did approach the Public Service Commission and say we signed off on stage one as being complete because we have that document, and stage one, as far as the Maryland Historical Trust is concerned, is not complete because of the archaeological sites being inaccessible and also because they've entirely missed the National Register property. The stage 2 solar would only sit 2 football fields from this National Register property in full view, in parcel 1 and 2.
Well, if that is accurate, that's a situation for Great Bay to resolve with the
Yes.
trust.
Yeah, well,
Okay.
we're hoping that would be resolved. Parcel 1 and 2 will be mitigated, moved, changed, canceled, or whatever.
If we can, let's move to your remaining items.
So, and the rest of the package just has a little bit of explanation concerning what happened. And you can just look through that to see what's what. I will turn the rest of these pictures over to you. And we're then therefore requesting that stage 2 be entirely reviewed, that all of the law cases be looked at where there's non-payment, because we have no guarantee that there will be any, past behavior is a good example of.
If you could hold on until you get back to the mic.
Yeah. So past behavior is a great example of future behavior, and until we can be assured that the contractors and the subcontractors will be paid, that there will not be environmental violations that are being ignored and fines that are being accumulated, that the Maryland Historical Trust is adequately doing its job in presenting the facts to you correctly, stage 2 needs to have a cease and desist, and the entire matter needs to be looked at more carefully.
Understood. I think you've made your point well. There's obviously a lot of pending litigation. Just one question for you.
Yes.
Did you file, with respect to your property, an application for National Register designation?
It's been on the National Register since we purchased it,
Thank you.
which was in 1982.
You may not be aware that we do have a requirement that any materials be provided to the commission at least a day before. We haven't seen this until just now. Council obviously hasn't had a time to thoroughly review this. Mr. Chasen, if you would like to respond, you may, but if you're unprepared to respond, you need not. So I'll leave that to you.
Just to be clear for the record, my objection from earlier stands. As you're alluding to, part of the problem with this stunt is that it doesn't give us any opportunity to respond. That notwithstanding, from what it is that I've heard and from what I think that you have intuited, none of this has anything to do with review of Phase 2.
All right, I wouldn't characterize this as a stunt, but there hasn't been a fair opportunity to review the material here. We do have this. This will be included in our record to the extent that we do have jurisdiction and it is relevant to the analysis. Are there any other parties wishing to speak with respect to Great Bay? Seeing none, Mr. Chason, do you have anything else to add at this point?
Nothing.
Okay, if you could all remain, let me ask if the commissioners have questions. Commissioner O'Donnell.
Question for Mr. Tolson on behalf of PPRP. So I was surprised by the vegetative buffer pictures that we were just presented, and I was actually surprised by the mitigated vegetative buffer pictures that we saw. What is DNR's view of that vegetative buffer? Because in this commissioner's mind, when I think of a vegetative buffer, I think of something that's going to shield the public's view of the generating installation, the generator, the solar.
Commissioner O'Donnell, I'd like to let Bob Sidzinski at PPRP answer that, because he's been in fairly frequent contact with the county people at Somerset County, and in fact, the buffer is something that he's recently discussed. So if I can turn it over to Mr. Sidzinski.
Good morning, Mr. Chairman, Commissioners. Bob Sidzinski, Maryland DNR Power Plant Research Program. And I have spoken to Somerset County extensively concerning the buffer, and at this point has stated, I mean, they were also not happy in the beginning. I recently spoke with them just this week, and they seem satisfied with the present buffer.
So my question is, what is DNR's view of that? Because when we approve these CPCNs, we get some assurances through DNR's conditions that there's a kind of a screening using vegetation of the view of these installations. Clearly, even that remediated installation doesn't do that.
This condition, it was one of our previous early conditions concerning vegetative buffer. And so it really relied on the county. The county's review, they had the boots on the ground, so to speak. And so we relied on the county. It didn't specify what they should be. It's my understanding right now that the buffer, there's 2 rows of plants, trees, staggered 4.5 feet apart. And that was sufficient for the county.
Yeah. And generally, does DNR view these vegetative buffers the way I think I view them, which is it will block the view from the roadway of the general public on these installations?
Yes, sir. Our new condition states fully buffered.
Okay, because clearly this doesn't do that. It might be able to check a box off on a form, but it doesn't block anybody's view of the installation. There's no buffer.
It's my understanding that it takes several years for these trees, they're giant arborvitaes, to grow to sufficient size to buffer. It's also my understanding, and I'm not a landscape architect, is that if they plant them too closely, they will die off.
Yeah.
So that's why they're spaced 4.5 feet apart.
Yeah, I don't want to question the technicalities of that, but I just want to have some confidence generally that when this commission reviews these CPCNs for these types of installations, that I have a clear view of what DNR is requiring these companies to install in the field on behalf of the citizens of the state of Maryland. And that's important to me. I know it is to you and to
Yes,
DNR
sir.
as well. So, okay, thank you. Looks like someone else has
No,
jumped
I'd
up.
like to recognize the director of PPRP, David Tankeville.
Thank you, Commissioner. Chairman and Commissioners. Yeah, my name is David Tansville, the Director of the Power Plant Research Program, and just in general on the buffer, that along with a lot of our conditions, the condition we are using has evolved over the years as we've learned a lot more. And conditions that were placed on projects years ago, such as this one, would not be sufficient in our eyes today. So we've learned a lot working with the counties and seeing how some companies have responded well and some haven't responded well. When we do notice that, when it is brought to our attention that maybe someone is not living up to the condition that was placed on them, we try to contact that company and work, as we have in this case, to rectify the situation. But I'll say that condition, that is a reason why we are waiting for a site plan to update our conditions. Because based on what we know now, we would word our conditions our recommended conditions much differently, and they will be, and you will see that with the updated conditions after we get a site plan.
Mr. Director, I wanted to tell you I appreciate that very much, and you know as well as I do that we're facing a potential large upgrade in our renewable portfolio standard, that these installations may be required with an enhanced carve-out going forward, and we're going to have a lot more challenges going forward. So I think it's in the Commission's interest as well as DNR's interest as well as the citizens of the state's interest to make sure that we have a handle on this and not
Yep.
let people check a box off and say they've installed something when they
Yes,
may
sir.
not.
And I think developers have recognized it's in their interest as the most public-facing item of their project, and it is harder for us down the road if we don't get this right on the projects that are going in now, and we recognize that.
Thank you.
Mr. Richard.
Yeah, for PPRP also, if I, before you both sit down, I just have a question as far as the next phase review. What will that involve, and along with the county review, what will that involve, and will citizens have an opportunity to engage and bring some of their concerns forward in phase two? Mr. Towson, is that? Okay.
When it comes to phase two, we have a preliminary site plan.
Okay.
But we've heard from the applicant that it is changing significantly.
Right.
But there's still issues that we're aware of now. Glare is one of those at phase two. Plus, they've not fully chosen the sites. Phase two could be as many as 4 sites. Right now, we have site plans for 1. So it's our understanding that they're only going to stick with the one site for phase two. That's why I would suggest there may be a phase 3. So.
Okay, and during these further phases, will there be citizen involvement? Will there be opportunities to provide their views, so that they can help in formulation of the new conditions?
That is a good question. I don't. Yeah. Yeah.
Commissioner Richard, I think I addressed this a while back with another thing where I said at one point that I was concerned that we were using admin meetings to sort of do almost like new CPCN proceedings. I think the commission has the authority to recommend public hearings be held before the new conditions are reviewed and approved, even though we're doing it sort of outside. I mean, the CPCN is final, it exists, but I believe that we could have public hearings if you want them.
Well, again, it sounds like the county is going to be providing input to PPRP.
Right.
And obviously, we can't dictate to the county what their process is going to be. But again, since this is an unusual circumstance where we have now a 2-phase, possibly now a 3-phase,
Right.
And significant issues have arisen, between phases, if there's going to be an opportunity, officially for our citizens again. So this presentation could be made, since we, as the chairman noted, we don't have jurisdiction specifically over historic trust or any of the details that go into the CPCN. We just look at the CPCN at the end with the conditions. It sounds like we're going to get updated conditions. So again, will there be an opportunity for citizens like today to do a presentation to?
Again, normally we submit our conditions, we don't have a final approved site plan, and that is going through the county process. There is some protection of the public in that we are asking for an approved site plan to go fully through the county process before we get it. So there is a further input from the public than we normally would have before we get it. We will submit our recommended conditions to the commission. It is up to the commission if you'd like to ask for a new hearing, but that.
Okay.
And it's also, I would also say that the county may have hearings. I don't know what their process is, but they would be the best place and the best host to have those types of hearings, since it's going to be primarily their permitting process. But I do believe that the commission always has the authority to order an extra public hearing. In many cases now, we have 2 public hearings. The statute only requires 1. But we do it because it's important to get public input and buy-in on these things.
Great. Yeah, I mean, often we don't have multiple phases of a CPCN either, but I kind of had the same impression that at the county level, that might be a good opportunity for citizens to engage and help influence what the county will recommend to DNR. So thank you.
Quick follow-up, if I might. How does PPRP or staff envision this coming back before the commission in terms of potentially revised conditions of the CPCN? How will we see this again?
Once PPRP receives an approved site plan from the county again, which will have more input than we usually have, because we don't usually have an approved site plan, we will submit our recommended conditions on the new site plan, but a lot of them will be updating conditions from the old that applied to the entire CPCN, such as vegetative buffer and things that we've learned and things we wanted to update. And we made that clear to the applicant that, if you want to move your date, PPRP is going to have an opportunity to refresh all conditions that we have placed on this, and we'll leave it to submit those conditions to the commission for review.
And I think in that respect, we would either have to come back for another admin hearing to have them discussed and approved, or, because they're embodied in the final order, they're attached to the final order that the commission has issued, or I guess you could refer it back to a public utility law judge to review and then provide a recommendation to the commission for final
Okay,
approval.
so it won't be a staff sign-off. Does staff agree with that it will come back before the commission? We'll get another chance to view this en banc?
I'm sorry.
Well, I would assume that you would get the final conditions, and also the applicant would need to file its request for a new construction date deadline change, although it might be included in the new conditions.
And Mr. Dean,
And they would also need to update some of the information that was in their application, the description of the final plan.
Am I going to get to view this again, is what I want to know, very simply.
Yes.
Yes, that's a yes for the record. Thank you.
So, if I might ask a question, perhaps Mr. Chasen, what's our time frame? Do we have, right now, are you asking for an indefinite extension of time? And, when do you think you'll get the site plan, and then we have 60 days from there? What are we looking at?
But my expectation is that site plan approval is going to happen later this spring. I don't have an exact date because this is all influenced by things that happened just yesterday evening at the local level.
Mhm.
Of course, I'm happy to provide more definitive information by letter to the commission when I have it, but just sort of in general, I expect site plan approval is going to happen sometime later this spring, probably in the June timeframe. I expect that 60 days after that we will have conditions. My hope is that just like in most CPCN proceedings, that we're all in agreement with those conditions, but quite clearly in answer to the commissioner's question, we will be back here with those commissions for your final sign-off. So I'm hopeful that we're going to be done with this process by Labor Day. I think that for the moment...
By Labor Day, did you say?
By Labor Day. When we come back in August with the conditions, the commission has an opportunity to ask questions, review it, that's the point at which we will be finished. Happy to provide further information. With respect to when we extend the deadline out to, we originally made our submission last year, and we had picked, I think, the end of August and the end of the year, I think, as the beginning and completion of construction. Given the passage of time and the fact that I don't even now know what the conditions will say, I don't think it makes any sense for us to lock in those deadlines. Those deadlines themselves are embodied within conditions. And so when the commissions are drafted and submitted to the commission, they should then have new deadlines, and you'll approve it in one fell swoop.
Okay. And Mr. Dean, is the staff amenable to a take no action motion? Because your original recommendation is to set a specific time frame.
Yes, Your Honor.
Thank you.
That would just be a note the filing, Mr. Dean? Would that be appropriate today, since, again, we have an extension in place now with no end date? They're already working on their interconnection service agreement. They're going to have to come back to us with an amendment. So, to Commissioner Herman's question, I mean, should we just note the filing today and leave it at that?
Since the filing would require future approvals, I think a note to filing wouldn't have any adverse impact.
Would not. Okay.
That's fine. Thank you. There will be an opportunity for the public to file comments in this case number 9380. Once modifications to the CPCNs are filed by PPRP, the public will have an opportunity to file any comments in the docket at that time. However, Mr. Jason, I would ask that even though many of the concerns and issues that were raised today by the public citizen is not properly before this commission, obviously he has the interest and involvement to come probably 3 hours this morning to this hearing. I would ask that Great Bay at least have a discussion with respect to his 12 items on his outline here.
We and the state agencies, I'm sure, will review all of these and incorporate them as appropriate.
Thank you. Do commissioners have any additional questions? Is there a motion?
Yes, Mr. Chairman. I move that we note the filing for item number 9.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved. Thank you.
Can I make one additional statement, please?
This item has been now concluded. If you have any additional comments, you should just file that on a letter in this docket.
Okay.
Thank you.
Moving to item number 10, Solar Hagerstown LLC filed on February 11, 2019, an application for an exemption from the requirement to obtain a certificate of public convenience and necessity to construct a 10.08 megawatt solar photovoltaic facility located at 1260 Security Road in Hagerstown, Maryland.
Michael Dean again on behalf of staff. Item 10 is an application filed by Solar Hagerstown LLC for authority to construct a 10.08 megawatt solar electric generating facility pursuant to Public Utilities 7-207.1 on property owned by and adjacent to the Holcim Cement Plant in Hagerstown. Normally, a person must obtain a certificate of public convenience and necessity prior to constructing an electric generating facility. However, under Public Utilities Section 7-207.1, a certificate of public convenience and necessity is not required if the proposed generating station has a capacity less than 25 megawatts and uses at least 10% of the electricity on site, with the remainder exported for sale in the wholesale market pursuant to an interconnection agreement. The statute also authorizes construction of a generating facility with the capacity up to 70 megawatts if 80% of the electricity is used on site. The statute requires that an application be on the form specified by the Commission and include a copy of the interconnection agreement with the local utility and proof of compliance with PJM's requirements, and that the Commission notify or require the applicant to notify elected officials representing the area within 1 mile of the facility that are in local municipalities, counties, or in the General Assembly. An applicant filing for approval under 7-207.1 is responsible for obtaining all local permits and authorizations for construction and for compliance with local land use and environmental requirements for the project. For solar facilities, Public Utilities Section 207.1, or let me start again. 7-207.2 requires the deposit of 1% of the installed cost of the project with the Commission to be refunded if the applicant demonstrates that it is fully authorized to commence construction within 18 months of the date of the application. The application filed by Solar Hagerstown meets the requirements for authorization to construct under 7-207.1. The 10.08 megawatt facility will be less than 25 megawatts, and as it plans to use the output on site for the cement plant, at least 10% of the power will be consumed on site. A copy of its interconnection agreement with the Potomac Edison Company and proof of compliance with PJM are attached to the application, as are copies of the notice sent to all municipal, county, and General Assembly members representing areas within 1 mile of the facility. The applicant also provided a deposit in the amount of $146,500, which represents 1% of its estimated cost of the project. Staff notes that the end of the 18-month period for the applicant to demonstrate that it is fully authorized to commence construction for the return of its deposit would be August 11, 2020. Staff recommends that the Commission approve the application and direct the applicant to notify the Commission in writing 2 weeks before the first export of electricity. If the company demonstrates before August 11, 2020 that it is fully authorized to commence construction, the
Commission should refund the deposit plus any reasonable administrative charges.
Thank you, Mr. Dean. Counsel for Solar Hagerstown LLC.
Good morning, Mr. Chairman, Commissioners. David Bugelmans on behalf of Solar Hagerstown LLC. I don't have anything to add to staff's summary of its buck sheet. We appreciate staff's support of the exemption request. I'm more than happy to answer the Commission's questions about this exemption request and also the project more generally. Thank you very much.
Thank you. Do commissioners have questions? Commissioner O'Donnell.
Just a comment, Mr. Chairman. I wanted to thank staff for working with me to fully understand this process, and they did an exemplary job of explaining some of the background on this. If you recall, this originally was filed with a checklist, and now I understand why. There was a time in the Commission's history when many of these applications were coming through in such a regular pace and such a high volume that made sense at the time. Since I haven't seen this particular one, or hadn't really thought about it, it caught me off guard. And so this more traditional buck sheet now is appreciated because now these are coming through at a much slower metered pace. I think I understand maybe 10 a year, something of that nature. So I appreciate it. I think it may help us going forward because of some of the controversies associated with siting of these facilities, even the smaller facilities. In certain rural areas of our state, and the concerns of local governments and jurisdictional authorities, et cetera, et cetera. I think these add to the record, make our analysis for both this commission, certainly for me, and for future commissions, more understandable and easier to digest. And staff helped me with that understanding and did provide the buck sheet at citing the appropriate law and giving a little bit more background and analysis. So I think, for the record, I wanted to thank them for doing that. Thank you.
Any additional questions? Seeing none, is there a motion?
Yes, Mr. Chairman. For item number 10, I move that we approve the application and direct the applicant to notify the Commission in writing 2 weeks before the first export of electricity and inform the applicant that when it demonstrates to the Commission that the applicant is fully authorized to commence construction, the Commission shall refund the deposit less reasonable administrative charges.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
The last item on the administrative agenda is 11, Access Community Solar LLC, filed on February 26, 2019, request for a waiver of operational deadline in Comar 2062-0304C.
Thank you. Is Counsel for Access Community present? Ms. Garofalo, good morning.
Good morning, Mr. Chairman, members of the Commission. Annette Garofalo on behalf of Commission staff. In item 11, Access Community Solar LLC is seeking a waiver of the operational deadline established by Comar 2062-0304C so as to extend that deadline as applicable to its community solar project for 6 months from the date on which the extension is granted. By way of illustration, applicant states in its letter that if the extension were granted on February 25, 2019, the project's operational deadline would be August 25, 2019. Access was issued a CGIS certification number on June 15, 2017, in response to its request to construct a 2-megawatt Type A LMI facility in the Delmarva service territory. Subsequently, due to limited space in the DPL queue, the company was required to reduce the size of its generating station to 0.72 megawatts, and also at that time, and perhaps as a result, changed its category type to open from LMI and its expected type of subscribers from LMI to commercial and industrial. When staff wrote its original comments, it appeared that applicant had been accepted into DPL's project queue on August 25, 2017, which would represent the latest date that would toll the time frame established under Comar 2062-0304C to determine the operational deadline for the project. However, by letter dated yesterday, March 25, 2019, and received by email at about 3 p.m. and hopefully by you
Well,
this morning.
we're just reading it. We just received it.
Access has indicated that no interconnection agreement was completed with DPL until July 16, 2018. Access states that in its letter that it does not know the reason for this delay in completing an interconnection agreement with Delmarva. However, without such an agreement, Access was unable to proceed with various steps necessary to proceed with the many steps necessary to develop its community solar generating station. Staff has checked both yesterday afternoon and this morning, and that's successfully checked, had communication with Delmarva regarding this issue. But Delmarva has not been able to provide any firm confirmation or denial of these facts or any explanation for the time frame contained in the recent communication from Access. It's necessary to determine the date on which the deadline for Access to request a waiver of the 18-month period allowed under COMAR expires in order to make a recommendation regarding the request that Access has made and whether its request for a waiver was timely. Thus, although it originally appeared that Access had failed to make a timely application for a waiver because it had been filed after the 18-month deadline established by COMAR, that is no longer clear. In addition, DPL seems to have retained Access in its queue rather than adhering to the regulatory deadline for refunding the company's escrow deposit to the Commission. Finally, although applicant offered little real detail regarding what justifies its need for additional time or its failure to timely seek that additional time through a Commission waiver of its regulation in its original filing, it has, through this letter, indicated what could be considered good cause for an extension of time. This changes the landscape somewhat, and staff requests the Commission deny the matter but without prejudice while we straighten this out with Delmarva. It may be that there is no need to actually even request a waiver. And
Ms. Garofalo, I'm sorry, could you clarify, straighten what out with Delmarva?
well, if what is stated in the letter from Delmarva is indeed correct, and I think the representative of Access will indicate that he doesn't know much more than what is in the letter due to his newness with the
If I
company.
could stop you there, Ms. Garofalo, do we have a letter from Delmarva? Because I don't.
We don't have a letter from
Oh.
Delmarva, only from Access.
Okay.
And so I've been in, since I got that letter yesterday afternoon, I've been in contact with Delmarva, but they are checking their own records to figure out what happened.
Okay, and I do not see Delmarva in the hearing room today, so why don't we hear from Counsel for Access Community Solar LLC?
Sure. Good morning, Commissioners. Brad Wilson for Access Community Solar. One quick point. I am not counsel for Access. I'm a staff representative, so if I'm using the term correctly, I guess I'm before you this morning pro se. Available to answer your questions. I don't have a ton to offer in addition to a net summary. The timeline that was set forth in the letter that you received yesterday is the company's timeline for the events that are leading to our request for a waiver. We would support the suggestion of staff to move forward on a path that allows the Commission to gather more information from the Delmarva to confirm that this timeline is accurate, and if so, maybe come back before you to reconsider the request.
Mr. Wilson, is that not your responsibility to have provided the information and gathered it from Delmarva to have it presented here today?
We have had conversations with Delmarva, and I do have to apologize. I am fairly new with the organization, and I was not personally involved in these events. What we've done is, in the letter that was sent yesterday, is made our best attempt to provide the timeline that we see it. We can certainly supplement that with copies of emails and notes internally. And if the Commission's interested in that, we can certainly do that within a number of days.
I recognize that you're new, but it doesn't seem like the Access community is making their best case before the Commission today. I have a few questions for Ms. Garofalo, but I'm still, even with this letter, trying to get a handle on all of the dates. At what was the date of the deadline, the expiration of the 18 months? That's probably the most important date here, and I'm guessing it's somewhere in November of last year, but I can't figure that out.
I believe that we had calculated that to be February 28th of this year, which would be 18 months from the date that the application was accepted by Delmarva.
Is it the date, Ms. Garofalo, that it's accepted, or the date that they applied to Delmarva?
Well, I think for the application to be considered complete, there needs to be an interconnection agreement that's signed. Now, it's not a final interconnection agreement because the facility hasn't been built, but it's an initial one. And I think it could be that what happened here is there was an initial interconnection agreement, but that was not good because the project had to be changed. It's made smaller, and then a new interconnection agreement was required, and it does not appear from at least this letter that that interconnection agreement was finalized with Delmarva until June 18th, 2018, and that's one reason I say it may be that access does not require a waiver of time. The 18 months may not have run.
Is that your position, Mr. Wilson?
Yes, listening to Annette reminds me of a discussion we had internally, and I think that we probably do need more information from Delmarva to answer that question. The interconnection agreement is an element of this application that's submitted for one of these projects, and if the completed interconnection application is part of a complete submission, then I absolutely would agree with that.
Can you tell me a little bit more about that? Because when you make a request for extension, you have to show either the two requirements or generally for good cause shown. In your initial letter dated February 25th, you stated that Access encountered delays in obtaining a final interconnection agreement. Is that the only basis for your request, delays based on the IA process with Delmarva?
I would say that compromises the brunt of the request.
Are there other issues that have resulted in delays?
I would say any other issues are resulting from the interconnection agreement delays. The interconnection agreement represents a certainty in the development of project that is typically necessary to have in hand before moving on to other steps that are dependent on financing or marketing to off-takers.
Ms. Garofalo, a moment ago you stated that Access failed to adhere to our regulatory deadlines and failed to timely request for an extension. But did I also hear that you said they may still be within the 18-month period? So can you reconcile those comments?
So in our comments, I believe the date we used was different than the date in this letter. It was a much earlier date, and it would have had them being late, albeit perhaps only a day or two by the most generous interpretation. But we did not have this letter at the time, so I'm looking for to see what I said in my comments about the date. I'm sure I must have listed it.
Mr. Wilson, I should just note that, as I noted with the previous gentleman, that commission practice, any correspondence needs to be provided to the commission by noon the day before. Filing it at 3 o'clock doesn't get, I'm just reading this for the first time now and trying to get my head around all this timetable here and do some math on the fly, which is never good for the moving party.
Understood.
I used, and this was taken from the original letter that came from Access, August 25th, 2017. So it's a much different tolling period for this, for counting the 12 months on which this 6 additional months is based, rather.
Yeah, one they're out of time, one they're still within the period, depending on what date we use. Let me allow other commissioners to ask some questions. I'll have a few more. Commissioner Herman.
Mr. Wilson, can you explain to me what other steps in development you are currently undertaking to demonstrate that you are in fact moving forward with the project?
Absolutely. The project has pursued and obtained its local land use entitlement. So any non-ministerial permit that would be required for the project to move forward has been obtained. Other permits, such as more ministerial permits, such as stormwater or building permit, have not been pursued, and they could not be pursued at this point in time. From my understanding, additional once the interconnection application was, or the interconnection agreement was finalized, then I believe the company began to pursue arrangement of financing and arrangement of off-takers for the project. And as that process continued, the 18-month deadline, whether or not, and whether or not that was in February or not, began to loom and cause difficulties moving any more meaningfully forward with those processes. So I think that's really what's driving the request and a desire to get this process resituated.
So in your letter, not your letter with the original filing, you stated that the company had expended considerable funds with respect to this project. Can you give us an estimate, a degree of, how much the company has spent? Because we want to make sure that if the commission were to grant this, that the company is indeed serious and it is indeed, moving forward with the project.
Certainly. A number at this time would just be a straight-out guess on my part, but I can obtain that information from the company and provide that to the commission right away.
Okay, and Ms. Garofalo, if the company were to, if the commission were to deny this request, would Access be eligible to file for a year 2 permit, and a year 2?
Well, they'd be eligible, but I'm not certain that there is any space left in the Delmarva queue for year 2 or year 3.
Okay.
I would have to check, but I believe it's full.
Oh, you believe it's full?
I believe it's full.
Okay. So if it's denied, then, subject, obviously, you're not certain, but if it is, then if it's denied, it's, they're knocked out of the pilot program.
That's correct.
Mr. Wilson, you should know.
Thank you.
What's the status of the year 2 queue or year 3 queue?
Well, the year 2 queue in DPL is full. Those were all awarded. Year 3, I wasn't aware had been opened yet. I thought it was coming at some point this year.
Okay.
So I think it may not be open, but I think applications have been taken, and it will be open sometime maybe in 6 months or so.
Okay.
So people are in line, I believe, for that.
Okay, thank you.
I got a request of staff. Ms. Garofalo, regardless of the decision we make on this item for access, I'd like to request that staff provide the commission with a more precise explanation of how this 18-month window tolls.
Certainly.
When's it commence and when's it end? Because right now I have this sense that it's floating depending on some nebulous interconnection agreement that may or may not change, and that's concerning for me. Could you make this a little more concrete for the commission?
I could.
Staff.
Yeah. You'd like me to send you something in writing, or?
Yeah, I think that would be preferable, just so we have a better understanding of how this works. So I have a better understanding.
Yeah, I'm looking at the regulations now. So the developer shall provide the following to the electric company upon application: the executed IA, proof of application of all applicable permits, and proof of site control. Now, if the developer fails to begin operating within 12 months of submission of that completed application to the subscriber, the electric company, in this case Delmarva, shall remove the project unless you pay the additional deposit and get the additional 6 months. But if the project fails to begin operating within 18 months of that initial application, Delmarva has no discretion, shall remove the project from the electric company's pilot program queue. In this case, it would be the year 1 queue. The fact that we don't have solid dates before us, and we should, is concerning. The fact that Solar Access Community Solar hasn't, in my opinion, been able to answer Commissioner Herman's question in terms of resources provided. Have you purchased solar panels yet?
No, solar panels would not have been purchased at this point in development.
You own the land, though, right?
The land is under site control. It's a lease scenario.
Has there been any improvements to the land in preparation for development?
No, we wouldn't be able to do that without a building permit.
What's the status of the permits?
Well, so we have our non-ministerial permits. So our special exception permit, basically any permit where it is someone's decision. It's a discretionary permit. Those are in hand. The more ministerial permits are the ones you would pursue right before construction. You have your engineering plans drawn up, and you get a building permit from the county, for example. So those would not be pursued until shortly before construction. But we do have the land use permits in hand.
Tell me why Access, initially it was an LMI project, and then it transferred to Open. Could you give me a little background regarding that?
I believe it was due to the fact that Access originally applied as a 2 megawatt LMI program, or as a 2 megawatt LMI project into the year 1 pilot program. That application was not accepted because the program, that bucket of the program was full by the time that Delmarva had received this application. Delmarva came back in, I want to say, August 2017 and said, hey, but we still have 720 kilowatts in the open category available. Would you be interested in pursuing that? And the company at that time made the decision to respond and say, yes, we would like to pursue that. Let's have the interconnection arrangement redesigned as a 720 kilowatt project.
So the fact that you initially were designated as an LMI project did not provide any preference when you transitioned to an open project?
I suppose that I don't know the answer to that exactly, only that...
It sounds like Delmarva invited Community Access to move into another category. Is that my understanding?
Yes, that's my understanding as well.
Did you request that Delmarva be present at today's meeting?
No, we didn't.
Mr. Garofalo, can you explain to me again what your recommended action is today? Is it not the recommended action as reflected on the buck sheet?
Well, we'd like it to be a little softer because we think that there are the rationale for our original recommendation, which was denial, was that it was filed out of time and it didn't show good cause, even if it had been filed within time. But as a result of the letter received yesterday, it appears that it definitely could have been filed within the right time frame, so it would be ripe for you to waive under just the limited operational time frame under COMAR. But in addition, there may well have been good cause shown if in fact the company was trying to get its application before Delmarva, and for whatever reasons we don't know, they were unable to get the interconnection agreement signed. And the reason I didn't just change this to a grant is that it's very unusual for it to take so much time. I mean, usually this is, maybe it could be a week, maybe it could even be a month in a difficult case, and this was more like a year. It could be that they actually forgot about Access because Access came in and got one interconnection study done, and then there was no one thought about the need for it to do a second one. I don't really know. So, and that's something that Delmarva will have to.
Well, I mean, cases like this, Ms. Garofalo, test my patience. The fact that Access Community files something on the eve of the commission meeting, which obviously has changed the view of staff counsel, and I have no way to tell whether or not these dates are accurate. There's no evidence attached to this. The moving party has not requested that the electric utility that they're interconnecting with be present to provide these facts today. But at the same time, I don't know right now. I don't know when the dates start, when the dates end. If you fail to timely seek an extension, Ms. Garofalo, would you suggest that we defer this item for 2 weeks, 2 months, 2 years?
Well, 2 years sounds good, but perhaps maybe 3 weeks, because that gives us 2 weeks to work on everything, if that would be amenable. Otherwise, 2 weeks is fine.
Madam Secretary, do we have a meeting 3 weeks from today?
I believe we do. Let me just check. That would be April 17th. The full commission would not necessarily be here, but there will be a meeting.
Thank you. Thank you. Do commissioners have additional questions? Commissioner O'Donnell.
Just a little finer point on my previous request. I want to have an understanding of how staff interprets what the chairman cited as regulation out of COMAR. So it uses the word application to kind of indicate the beginning of the clock, the initial 12-month clock. Staff is alluding to an interconnection agreement and a modification of an interconnection agreement. And I want to understand how that's interpreted as it's kind of operated by the regulations. So when an interconnection changes, how is that viewed? How is that interpreted? How does that affect the tolling of the clocks on these projects? I hope I'm being clear on that.
Yes.
Okay. And I'll just also say to the company, Mr. Chairman, excuse me, I'm glad you didn't request a waiver of timing requirements for construction delays due to winter weather.
Has that been a common theme around here?
So, Mr. Chairman, if I might have another question for Ms. Garofalo. Ms. Garofalo, I think what I'm hearing is that if this timeline is correct, and if you can prove that this timeline is correct, that the question of a waiver is not even ripe at this point.
That's correct.
Because we're not beyond. So, if we were to deny it, that doesn't impact the fact that, the only reason we would grant it, potentially, is that it in fact is not ripe, because they are not out of time. And so, if the commission were to say, we're going to deny it because it's not ripe, potentially, then we can deny it, and then they can come back. If these facts are proven out to be true, when it does become ripe, they can refile. There's no prejudice because it wasn't, because it wasn't ripe. Do I have that right?
If I understand, you're saying if you deny it as filed, you, based on what's in the letter, that would be correct denial under the regulations, or you would have found it to be a correct denial under the regulations. But that should additional time not be needed under the regulations, that the denial of this would not have any effect. And I guess just looking forward, but should for some reason they not complete within whatever time and they need a future waiver, they could still come back for that.
Right, that's what I'm trying to get at, because if the facts contained in the original letter are not accurate, because we now have the second letter that suggests that maybe the application didn't become final until June of 17, I think that's the date. Then this first letter, there's the facts in here are not accurate.
Yeah.
Do you follow? I mean, I'm trying to understand. If we defer it, and it turns out that it is not, in fact, ripe yet, because in fact the interconnection agreement and therefore the application didn't become final until June. If we defer it, what are we deferring it for? Because if we defer it, then what action do we take at that point? Then we just dismiss it because it's not ripe, or they withdraw it? Just trying, because what action would we take if it turns out that it's not ripe?
I don't think you'd need to take any action, but I recognize your quandary.
Yeah, that's, you know.
So you could deny it. We could, we being the company and Delmarva and I could figure out what really went on and why.
Right, and then we don't have to see it again until they, you know, if they are unable to complete their construction within time, they might come back and make a waiver.
Right.
And they'd have to make they'd have to make the showing for that waiver.
Right.
But in fact, then we wouldn't have to defer it and come back to all of this again. So I'm thinking, if we do that, if we do defer it, I'm not sure what action we would take if it turns out that it's not right, Mr. Chairman.
No,
That's where I'm coming from.
You raise a good point. If it's not ripe, we don't even need to be here, and you don't need to make a request. But if the dates are such that your 18 months has expired, and we deny the request, Access Community is done. So, Commissioner Herman, you raise a good point. I know Commissioner O'Donnell's question is still standing. As I understand it, a completed action begins when you satisfied all the remarks that I just made, in addition to having a completed IA, and you don't have a completed IA. Is that right?
Not in August of 2017.
When was the agreement with Delmarva finalized? Is there a date on here?
Yes, I'm told July 16, 2018.
Well, I would say June 18.
June 18?
But it was, they got their proof that it was finalized.
They got
July.
proof on the 16th of July.
Right.
June 18th, Delmarva connects Access with one of their staff engineers, and work begins with back and forth discussions.
That's not final.
Yeah, I don't know.
Oh,
back
July
and,
16th.
Yeah, okay,
correct.
all right.
Right.
Yeah.
I was
back and forth
confusing
discussions.
it with the August 31st date. You're correct. That's correct.
Just why would it not be August 31st when it's marked as acknowledged receipt? I'm just curious what the meaning is between these two dates. It's July 16th and August 31st.
Well, I would say that it may be a date in between. It may be a date we don't even have.
Well-
But July 16th, Access signed it, and it sent it to Delmarva, who presumably signed it. And the interconnection agreement was marked, acknowledged, received by DPL. It's definitely done by then. And if we were, and what I tried to do when I wrote my original comments is give them as much time as it looked like the facts allowed. But, and so you could say that that was the right.
And if
right.
that in fact is the date, July 16th, 2018, obviously we're well within 18 months.
So, Mr. Garofalo, who actually is the drafter of the interconnection agreement? It's the utility company, is that correct?
Correct.
Okay, so they would draft it and then submit it to, in this case, Access for their review, signature, and then returning it to the utility company.
Yes, there are regulations that say what has to be in that interconnection agreement, and there's some study that is done behind those regulations as well. But the utility company controls the interconnection agreement.
Okay.
That's what. In your first letter, Mr. Wilson, you suggest that within 6 months after receiving at this point for a waiver, but is that correct? Once you have all your paperwork in order, is that still true? Within 6 months, you can be operational.
Certainly, assuming the start of the 6 months is not in, for example, November.
Okay.
But it's a small project. The land use entitlements are already in place. It's a very straightforward site to construct. Once we have the certainty that we need surrounding the extension or waiver or not issue, then we could proceed very quickly.
Okay. So if we get this timeline straightened out here and quickly, it's very possible you could almost be up and running before any waivers required.
It's possible, and there would be a strong desire to get done this year. For sure.
So maybe deferral is the.
Mr. Wilson, I must admit I'm thoroughly confused. I recognize you're new. Did you fly down from Minnesota last night?
Actually, I live in Iowa, but yes,
Iowa.
Midwest.
Okay, so thank you for coming.
No problem.
This way. At this point, I can't even tell if you need a request for a waiver or not. The fact that you filed it perhaps without getting the full information from either Delmarva or staff council, puts this commission in a quandary. So what I would propose to do, recognizing Commissioner Herman's concerns, is bring you back out here in 3 weeks. In that time, you'll have time to hopefully convince Delmarva to appear here to explain their side of what happened. They're under no requirement to be here, so you do your best to convince them. Work with Ms. Garofalo and staff council in order to resolve this. You have 2 letters. You might not even need to be here today. That's the impression that I'm being left with. So sort this out. You have 3 weeks, and we'll see you on April 17th. Do any commissioners object to that plan? No? Okay. Thank you. So we'll defer this to April 17th. Is there a second?
Second.
All in favor? It's not, well, the motion or whatever, just come back here on the 17th. Thank you. Thank you, Ms. Garofalo. Is there any additional matters or business before the commission today? Seeing none, this meeting is adjourned.